So in 2021, the lifetime gift tax exemption is $11,700,000 for an individual, twice that for a couple. Now, it had been $5 million. The Trump tax changes, tax cuts for some, jumped it to $10 million. It's been indexed for inflation, so it's 11.7 this year. And they are slated to continue until 2025. Now, it's what happens, according to the IRS, when the lifetime exemption amount, or the BEA, reverts back to pre-2018 levels, which were about $5 million. So they're saying on November, here, I'll just read the whole thing because it's interesting. There's more in the members area at winnerscheck.org. On November 26, 2019, the IRS clarified that individuals taking advantage of the increased gift tax exclusion amount in effect from 2018 to 2025 will not be adversely impacted after 2025, when the exclusion amount is scheduled to drop to pre-2018 levels. The IRS formally made this clarification in final regulations released that day. The regulation implemented changes made by the Tax Cuts and Jobs Act, that's the Trump tax cuts for some, not in California, for some not in California, let's put it away. Tax reform legislation enacted in December 2017. Here are some questions. So, the tax law reform doubled the BEA for tax years 2018 to 2025 because the BEA, that's the lifetime exemption, but it's also the basic exemption amount because you don't have to wait until you die to take it as long as you report it properly using Form 709. Again, covered more at winnerscheck.org. The BEA is 11.4 for 2020, and if you look at the website, it was 11.7 for 2021. Under the tax reform law, the increase is only temporary. Thus, in 2026, the BEA is due to revert to its pre-2018 level of $5 million as adjusted for inflation. And then, how did the IRS clarify the law? This is big because it can form sort of an analogy for what if the Democrats were to change it next year. Or, the Democrats and maybe Mitt Romney. That's just a little joke. To address concerns expressed by a number of stakeholders, the final regulations clarify that people taking advantage of the increased BEA by making gifts during the period 2018 to 2025 will not be harmed after 2025 when this amount is scheduled to drop. The regulations provide a special rule that effectively allows the estate to compute its estate tax credit using the greater of the BEA applicable to gifts made during life or the BEA applicable on the date of death. As a result, people planning to make large gifts between 2018 and 25 can do so without being concerned that they will lose the tax benefit of the higher exclusion once it decreases. Now, I suppose there's a little bit of a hole in there in that the IRS is talking about the fact that it's scheduled to change for 2026. What if the Democrats did it sooner? But I can't imagine the court. I mean, some of this money will get distributed. I don't even know how they go back and get it. How would they claw it back? So I, as a lawyer, if I wrote an opinion letter, I would, and I'm licensed in California, so I can talk about federal tax matters, I would have to write a disclaimer saying, but we cannot predict for sure how it will be done. So if you can, protect yourself. So maybe give all 11.7 or 23.4 if you're a couple to your heirs or your kids or friends, but tell them not to use the money for a few years and make sure it's invested well so you can claw it back and pay the IRS, the taxes, if you have to. But I think if it were me, I'd be pretty comfortable with this language here that as a result, people planning to make large gifts between 18 and 25 can do so without being concerned that they will lose the tax benefit of the higher exclusion level once it decreases. So that's it. I don't think any lawyer will guarantee it. Lawyers don't guarantee anything in their opinion letters. I would restate this. I would explain it. I would talk about how it makes common sense. I would also say, but you may want to protect yourself. I don't see any other way around that. However, if I had a lot of money and I wanted to take advantage of that, and I have other videos talking about all the other, like there was a Bloomberg article talking about all the ways the ultra wealthy are finding ways to transfer assets to their heirs tax-free or at very reduced tax rates. I would consider those things as well. but I would take advantage of the 11.7 or the 23.4 if I was liquid, because it's a big number historically for this BEA. Now, if you're seeing this, but you haven't had a consult with our office, or you haven't become a client, go to winnerscheck.org, set up a consult. What we like to do for our clients is we can help people looking to buy properties get a large, let's say they're buying $1 million property and they don't have a $200,000 down payment. We can consult with their grandparents or their parents or even a friend and explain to them how they can gift without experience a tax-free according to the IRS rules. If you're a grandparent and you want to help out your kids now so they can get a head start on income properties or a down payment or even buying the home for them, we can show you how to do that. We will follow. Basically, we refer out real estate purchases all over the country. We will oversee the file, and we'll also make sure that we will oversee the fact that your tax forms get filled out properly. We will talk to your advisors if they don't understand the rules. We will, as part of our consultation practice, we will oversee the transaction and help ensure that it's done properly. So if you'd like to learn more, go ahead and talk to Phil. Well, Phil's working with me on this, but it could change depending on when you see the video. But go ahead. Phil I've been working together for 10 years. I'm not saying Phil won't be around. I'm just saying he might not be the one doing it. But go ahead, go to winnerscheck.org, learn more, set up a free consult, a free strategy session, and we'll see if we can help and work together. Thanks. Talk to you later. Bye. My name is John McConnin. I'm a real estate attorney and a broker, licensed in California.